to begin by acknowledging the traditional custodians on whose lands the Australian National University sits, and from whose lands I'm speaking to you today, the Ngunnawal and Ngambri peoples, as well as the traditional custodians of the lands on which each of you live, work and learn. The First Nations people of Australia have had an intimate relationship with this landscape for thousands of years. They have met on country to learn and share knowledge, to talk and to listen, and to discuss ideas and solve problems. And they have used that knowledge and these ideas to care for the country and to practice law thousands of years before the systems of international law that we meet tonight to discuss came into being. As we come together tonight, I'd like to pay my respects to the elders of this country, past and present, to the culture, knowledge, kinship and connection that they hold in relationship to country, and the legal systems that they developed and maintain today. I'm so thrilled to welcome you all tonight to the annual Kirby Lecture in International Law here at the ANU College of Law. My name is Imogen Saunders and I'm the Director of the Centre for International and Public Law, or CIPL as we call it. CIPL has sponsored the Kirby Lecture since 2008, launching the series to recognise and pay tribute to the pioneering international law work of the Honourable Michael Kirby. We are delighted to have Justice Kirby with us here tonight, and I want to acknowledge him and thank him for his presence as we gather here for the 15th iteration of this lecture series in his name. The Kirby Lecture has become the foremost public international law lecture within Australia. It has been given previously by luminaries including judges of the International Court of Justice, Judge James Crawford, Sir Kenneth Keith, Judge Christopher Weramantry, and of course Australia's current judge on the ICJ, Judge Hilary Charlesworth, as well as outstanding and leading international law academics, including Professor Anne Orford, Professor Fleur Johns, and Professor Gary Simpson. Our speaker tonight, Professor Tim McCormack, sits very comfortably in this list of international law superstars. Although Tim is Professor of International Law at the University of Tasmania and a proud and passionate Tasmanian, he also has deep links to Canberra and the ANU. He undertook a sabbatical here 30 years ago, using the office of Philip Alston, himself a past director of CIPL. We are very glad to welcome Tim back to Canberra and to CIPL this year. Tim is also the Special Advisor on War Crimes to the Prosecutor of the International Criminal Court, a role he has held since 2010. Prior to this, he was a member of the Australian Government delegation to the Diplomatic Conference in 1998 for the negotiation of the Rome Statute, and he has been closely involved in the work of the International Criminal Court since then. This year marks the 25th anniversary of the signing of the Rome Statute and the 21st anniversary of its entry into force. In light of these milestones and of the ongoing conflicts around the world that sadly continue to give rise to allegations of war crimes and crimes against humanity and other international criminal offences, it is an apposite time to have Tim here to reflect on the role and work of the world's first permanent international criminal tribunal. However, it is worth noting that Tim's work on justice is not exclusively orientated towards the international. In 2021, Tim worked with Professor Kate Warner, the former Governor of Tasmania, on the Pathway to Truth-Telling and Treaty report that was submitted to the Tasmanian Premier. The report is thoughtful, thought-provoking, heartbreaking and hopeful. It reminds us that as international lawyers, while we seek justice for international crimes, there remain many heinous crimes and injustices committed in this country against our First Nations people that have never been addressed and from which the consequences are ongoing. Tim's primary fields of expertise, international criminal law and international humanitarian law, develop to protect people and communities from the very worst behaviours of others. They seek to hold accountable those who perpetuate such crimes. In 1945, Justice Robert Jackson gave the opening statement at the Nuremberg trials. Jackson famously described the weight of the task ahead as, "The wrongs which we seek to condemn and punish have been so calculated, so malignant and so devastating that civilisation cannot tolerate their being ignored because it cannot survive their being repeated." In their Pathway to Truth-Telling and Treaty report, Tim and Professor Warner also warn against the perils of ignoring grave wrongs within a country's past. Societies that ignore violent pasts characterised by egregious injustices perpetuate the lack of resolution for future generations. Their call for truth-telling and treaty as steps to reconciliation is powerful. We, of course, will have an opportunity later this year to vote in the Voice referendum. The the result of which will hopefully be another step forward on the long path towards achieving justice within our country for the wrongs of the past. These fundamental concepts of justice, accountability, and addressing wrongdoing underpin the topic of Tim's lecture tonight, the International Criminal Court and Global Criminal Justice. Are we making progress? Please join me in welcoming Professor Tim McCormack to give the 2023 Kirby Lecture in International Law.
If I had prepared Imogen's introduction of myself, which I surely did not, I could not have written it better. I really appreciate that introduction, Imogen. When I undertook that work with Kate Warner in Tasmania, with our First Peoples, I never saw a disconnect between the work that I do on a global stage and that opportunity, and I'm really glad that you can draw that connection and see it yourself. Thanks very much. But it's really special to be back at ANU. Had a wonderful time here back in 1993. And I've been back many times at ANZIL conferences and other events here, but it's wonderful to be here in this capacity. And I absolutely agree with Imogen about this coincidence of major milestone anniversaries. 25 years since opening for signature of the Rome Statute, 21 years since entry into force, 20 years since the foundation judges and the prosecutor and the registrar were sworn into office in The Hague in a ceremony presided over by Queen Beatrix. So this is an opportune time to reflect on some of what's been achieved, to reflect on some of the criticisms and some of the ways the court has had to adjust, but also to think about where we're at now and what could be in the future. I'd like to start with a reflection on the past, taking you back to 1998. I think the first observation I would make, and certainly others in the room who participated in the Australian government delegation in that diplomatic conference, is that it's a good thing it happened in the 1990s because there's no way it would happen now. Had we not been able as an international community to gather in Rome and negotiate the statute for the world's first permanent international criminal court back then, we couldn't try and do it now because of the current global climate. I had the enormous privilege of joining the Australian government delegation for 2 weeks. An appalling place, you can imagine, Rome for a diplomatic conference of 5 weeks duration. Richard Rowe led the delegation and he was also chair of the like-minded group, and that was a group of states from all the geographic regions of the world that came together with a shared commitment to an effective and robust international criminal court. And Richard did a brilliant job on behalf of Australia in chairing that. But it's really great to acknowledge a couple of other members of the delegation team here with us tonight. Mark Jennings is here, who drafted the famous Jennings Rules on Evidence and Procedure, which became the basis on which the current Rules of Evidence and Procedure at the court developed. We also have Jeff Skillen here, who was then representing Defence on the government delegation. May or may not have been true that Jeff and I and Gary Simpson, who was also on the team, nicked off from Rome for a weekend to London to watch Bob Dylan and Van Morrison in concert at Wembley Arena. When I tell that story to my dear friend Klaus Kress from Germany, who was part of the German delegation, his reaction was one of he was appalled, he was just shocked, incredulity. How could you have done that? Well, I said, were you being paid by the German government to be there? Yes, I was. Well, I was a volunteer. And I reckon it was a highlight of the experience. Helen Brady, now head of the Appeals Division in the Office of the Prosecutor, the International Criminal Court, was a member of the delegation. Indra Rosenthal, now a PhD student of mine, I'm proud to say, at the University of Tasmania. And Gary as well. We had a wonderful time together. I think about that decade of the 1990s. It was a halcyon period in both the making of international law and in the creation of new international institutions. The decade, of course, was marked by the fall of the USSR, the Berlin Wall came down, and there was all of a sudden a new opportunity for multilateral cooperation. And the window of opportunity was seized. It was the decade that resulted in the conclusion of negotiations to the Chemical Weapons Convention and the opening of the establishment of the OPCW, the Organisation for the Prohibition of Chemical Weapons, also headquartered in The Hague. Gareth Evans had a profoundly significant role as our Foreign Minister in helping break through those negotiations. That was the decade of the Ottawa Convention, prohibiting anti-personnel landmines, and also the Oslo Convention, prohibiting cluster munitions. The Security Council in that decade established both the Yugoslav Tribunal and the Rwandan Tribunal, and of course the Rome Statute to create the International Criminal Court was concluded. I think it's a sad reality that much of what was achieved in the 1990s could not be replicated in this decade, but that's a consequence of the current multilateral climate of suspicion, enmity, and open hostility. I naively assumed back in the 1990s that this was the start of a new era and it would always be like this. But of course, that is not the truth any longer. And I think despite the global existential threats that we face, I guess climate change and nuclear weapons are two of them that are most obvious, it's tragic to witness the unravelling of some of the structures and processes that I naively assumed 30 years ago were unassailable. But in 1998, the international community did successfully negotiate the Rome Statute, and in the early hours of the morning literally after midnight on the 17th of July, when the chair of the conference, Philippe Kirsch from Canada, banged his gavel to announce the Rome Statute is hereby adopted, the room erupted into spontaneous applause and a palpable sense of the historic significance of what had just been achieved. Everybody was aware of that. This was the adoption of the constitutive instrument for the world's first permanent international criminal court. In English alphabetical order, Australia appears in multilateral fora between Argentina and Austria. When the gavel went down, the Argentinians were on the table dancing in jubilation, but we're used to such displays of emotion from the Argies. Next to us, we saw an unprecedented event in multilateral affairs. The head of the Austrian delegation cracked a smile. And all of us knew this was truly an historic moment. If only we could have captured it. I think the sighting was probably rarer than thylacine sightings in my own home state. There were great expectations uttered at the opening for signature ceremony, a very grand ceremony in the great Italian tradition. Kofi Annan, then UN Secretary-General, had this to say about the significance of what had just been negotiated. By adopting this statute, participants in the conference have overcome many legal and political problems which kept this question on the United Nations agenda almost throughout the organisation's history. No doubt many of us would have liked a court vested with even more far-reaching powers, but that should not lead us to minimise the breakthrough you have achieved. The establishment of the court is still a gift of hope to future generations and a giant step forward in the march towards universal human rights and the rule of law. It's an achievement which only a few years ago nobody would have thought possible. Big claims, not sure that I've actually quite seen those achieved in the International Criminal Court, but that's the sense of optimism and expectation, I think, that prevailed right at the end of the conference. I can remember coming back to Australia after our involvement in Rome and understanding that the most optimistic expectations about when the statute might enter into force were 5 years, and there were some pretty pessimistic ones that 20 years, if ever, it will take for this thing to actually come into existence. I don't ever remember hearing anybody talking about the possibility that it all might happen within 4 years, but that is actually what happened. We know now that in the middle of April 2002, the 60th instrument of ratification was deposited at UN headquarters in New York, and that triggered entry into force on the 1st of July 2002. And once that middle of April 60th instrument triggering the time frame happened, then there was a mad scramble, including here in Australia, for original state signatories to ratify their signatures in time to be amongst the group of original states parties when 1st of July happened. Here, some of you may remember, Australian ratification was no sure thing, and the story of how we almost didn't ratify the Rome Statute is a separate story for another time. Richard, no, I won't tell it because it'll, but I'd love to another time. Richard Rowe will never forget flying to New York with the Australian instrument of ratification, not exactly down his underpants, but certainly under his constant watch. You should ask him about, the nervousness of all of that. On the weekend of the 29th to the 30th of June 2002, so that he could be there when the Treaty Secretariat opened up on the 1st of July to deposit that instrument of ratification and make sure that Australia was an original state party. On a more serious note, there is a sense in which the International Criminal Court was a natural progression of what had gone before. Nuremberg and Tokyo in 1945 to 1948, and all the literally thousands of subsidiary trials that happened at the national level in the period from 1945 through to 1951, including 300 Australian trials conducted by military courts established pursuant to the War Crimes Act of 1945 in this country. That was a really important part of the historical development of international criminal law and the establishment of tribunals to hold individuals accountable. We know that the establishment of the ICTY and the ICTR by the UN Security Council in the early 1990s was so formative and influential in creating the environment for a successful diplomatic conference in Rome in 1998. And since then, from 1995 through to 2017, it's been a succession of so-called internationalised or hybrid tribunals. The Special Tribunal for Lebanon, the Special Court for Sierra Leone, the Extraordinary Criminal Chambers in the Courts of Cambodia, and the Kosovo Specialist Chambers set up in The Hague. But all of those tribunals have been ad hoc for specific conflict situations. And now with the ICC, we've moved on from victors' justice, from ad hoc tribunals dealing with particular conflicts, even if for both sides of the conflict, in the ICC to realise the dream of a permanent international criminal court. So there's an evolutionary process, and the ICC is a natural progression in that process. But there's another sense in which the ICC wasn't just a mere progression, or isn't just one, but a quantum leap over what went before, one that represents a challenge to national sovereignty. After all, the Rome Statute grants jurisdiction to the ICC over the conduct of nationals of non-states parties in certain circumstances. UN Security Council referral, we know of the Darfur referral in 2005 and the Libya referral, when neither Sudan nor Libya were states parties to the Rome Statute. But beyond the authority of the UN Security Council, when conduct in question occurs on the physical territory of a state party, one could argue, of course, that the intervening state's nationals are subject to the territorial jurisdiction of the host state, so it's not actually a threat to sovereignty. But the issue is that the ICC, when it's looking at conduct occurring on the physical territory of a state party, has the consent of that physical or territorial state, and so jurisdiction over the conduct of individuals irrespective of their nationality. That's precisely the context in which the ICC has jurisdiction over Vladimir Putin in Ukraine because of the conduct occurring on the physical territory of Ukraine. Well, we had some incredibly hostile opposition from the United States early on in the court's history. So there was a great moment in Rome. There was some pretty rapid progress towards entry into force, and then the court sort of started to materialise. But in that period of time, the Bush administration was openly hostile to the emergence of this new institution. When the US delegation in Rome failed to get its way on exclusive referral of situations by the Security Council, that's what they were asking for, and then having failed on that, to not secure the requisite consent of both the territorial state and the state of nationality, the US embarked on its global campaign to sign up the rest of the world to bilateral Article 98 agreements. Article 98 is a provision of the Rome Statute, and paragraph 2 of that provision says, "The court may not proceed with a request for surrender which would require the requested state to act inconsistently with its obligations under international agreements, pursuant to which the consent of a sending state is required to surrender a person of that state to the court, unless the court, of course, can first obtain the cooperation of the sending state for the giving of its consent." I imagine the US deployed an army of lawyers to go through the Rome Statute like a fine-tooth comb, and someone found this provision, and it was a big aha moment, and then they invested untold resources in sending emissaries out to the world to sign everybody up. They claim to have signed about 120 such bilateral agreements. In Australia's case, we'd consistently said, at least this is what I understand to have been the official position, not being privy to any of the conversations, but I understood the official position to be we would sign an agreement provided it was not inconsistent with our Rome Statute obligations. And it wouldn't be inconsistent with those obligations as long as the agreement specified that we would not hand over a US national to the ICC without US consent, as long as the US undertook a rigorous and bona fide investigation of the allegations against the wanted individual. That would be entirely consistent with Article 17 and the so-called complementarity formula. As far as I know, no such agreement was signed with Australia, and the momentum for Article 98 agreements petered out. I have heard, anecdotally, that Jordan, a state party to the Rome Statute, largely because of the incredible efforts of Prince Zayed, who was such an influential figure in the diplomatic conference, Jordan had refused to sign an Article 98 agreement, even if it cost them their annual $1 or $1.5 billion in military assistance. And then, having taken that position, the US apparently backed down because Jordan was a very important partner in the global war on terror, and that was more important to keep them on side than to have a bilateral agreement with them. In addition to Article 98 agreements, the Bush administration passed the American Service Members Protection Act of 2001, definitely worth a read, referred to colloquially as the Hague Invasion Law. It's only for domestic consumption. We'd never use it, but that line didn't seem to satisfy the Dutch for some reason, a NATO ally of the US. Under the Hague Invasion Law, the relevant provision of the American Service Members Protection Act states that it authorises the President to use all necessary means, code word for very serious lethal military force, including the provision of legal assistance to bring about the release of covered US persons and covered allied persons held captive by or on behalf of the request of the court. Yeah, imagine the Dutch, NATO allies, supposed to be, in an alliance, being told that we reserve to ourselves the right to use whatever force is necessary to blow a hole in the wall of the prison at Scheveningen and take our guy out. Well, this is a big challenge to a new institution. But it didn't stop the court coming into existence. The election of President Obama took a little bit of heat out of the US opposition, but in the first decade of the court's existence, the big criticism then was that it was anti-African. It was only dealing with African conflicts. And it's true that the first 4 self-referrals by states parties from the Democratic Republic of the Congo, Uganda, the Central African Republic and Mali all were from the African continent. The 2 UN Security Council referrals, Sudan and Libya, obviously both on the African continent. And the first 2 requests by the prosecutor acting proprio motu, that is, asking the pre-trial chamber for approval to open a formal criminal investigation, were for Kenya and Cote d'Ivoire. There was an attempt by Palestine to self-refer the situation there, but that was rejected first time around. There was a lot of criticism of this African-centric focus. The ICC was said to be anti-African, racist, biased against the global south, not prepared to take on Western nations for their alleged Rome Statute offences. A number of states parties threatened to withdraw from the Rome Statute, including South Africa, Kenya, Gambia, Burundi and the Philippines. In the end, only Burundi and the Philippines did withdraw, although the ICC still retained jurisdiction over the situations in both states while they were states parties. The deputy prosecutor at the time, who subsequently became the second prosecutor, Fatou Bensouda from the Gambia, spoke passionately and with some authority in response to these criticisms. There's a good reason why the ICC is so focused on African situations, she said, because tragically, the African continent's been subjected to a litany of armed conflicts. And in 6 of 8 initial African situations before the court, the governments of those states or the Security Council had requested the ICC prosecutor to intervene. I believe that much of the African-focused criticism of the court was unfair, although I always accepted that the court was created not for Africa but for the world. And so the approval of the Georgia and the Afghanistan proprio motu requests to open formal criminal investigations were welcome counters to this allegation of African bias to which the court had been critiqued and subjected. In the second decade of the court's history, it was faced with extensive and widespread criticism. It's one thing to try warlords of non-state armed groups operating within the territory of states parties, but a qualitatively different thing altogether, certainly a significantly more controversial matter, to investigate nationals of non-states parties in respect of their conduct on the physical territory of states parties to the Rome Statute. Precisely the situation in respect of the investigations into Georgia involving Russian forces, Palestine involving Israeli forces, and Afghanistan involving the US and other coalition forces. The prosecutor in November 2017 asked the pre-trial chamber for approval to open a formal criminal investigation into the situation in Afghanistan, including not just Taliban or Afghani government forces, Rome Statute offences, but also offences perpetrated by the US and other coalition forces. It was only a few months after that President Trump's National Security Advisor, John Bolton, launched a tirade against the institution of the court in a speech to the Federalist Society in Washington, D.C. It was in September of 2018. He said, "Today, on the eve of September 11, I want to deliver a clear and unambiguous message on behalf of the President of the United States. The US will use any means necessary," they like that phrase, "to protect our citizens and those of our allies from unjust prosecution by this illegitimate court. We will not cooperate with the ICC. We will provide no assistance to the ICC. We will not join the ICC. We will let the ICC die on its own. After all, for all intents and purposes, the ICC is already dead to us." Ooh, Big language. President Trump imposed sanctions on the ICC prosecutor, Fatou Bensouda, and on other named senior officials of the Office of the Prosecutor by way of executive order issued in June 2020. In that order, he even declared a national emergency to deal with the threat of the possible ICC exercise of non-consensual jurisdiction over US nationals. That was a pretty stressful and challenging time for the court. I remember it well. While the US was strident in its criticism at the time, many other states parties, academic commentators, NGOs were also concerned about the court's operations and its lack of efficiency. The Assembly of States Parties, the governing body made up of all of those states party to the Rome Statute, instituted an independent review of the International Criminal Court and the Rome Statute system. And the panel tabled their 350-page report with its almost 400 recommendations in September 2020. The review is comprehensive. It covers all organs of the court and all aspects of the court's performance: inefficiencies of process, resource allocation, poor management of staff, failure to achieve deliverable outcomes, processes for nomination and election of judges, etc. But that review is actually constructive, stark contrast to the attitude of the Trump administration. The review is designed to consolidate and strengthen the institution of the court, not to undermine or dismantle it. The organs of the court and the principals, by that I mean the President, the Prosecutor and the Registrar, have welcomed the review and its recommendations, and the new prosecutor, Karim Khan, was elected on a reform platform. He's deeply committed to ensuring that his office, at least, grapples with the recommendations that apply to it. But despite this more constructive approach of the review, as recently as late 2021, I really wondered if the institution would survive. Was it ahead of its time? And would the Assembly of States Parties actually rally around the court, defend it and strengthen it? Or would they simply let it wither and die, perhaps like the League of Nations, in its inability to live up to its ideals and prevent the outbreak of World War II? Well, there's been a monumental shift, and that happened as a consequence of Russia's invasion of Ukraine. That invasion, of course, has been devastating for the Ukrainian people. We've witnessed egregious violations of IHL on a daily basis: the targeting of civilians, towns and cities, widespread rape and sexual violence, summary executions, intentional targeting of fleeing civilians, high explosive rounds in densely residential areas, the intentional targeting of schools, hospitals, churches, the deportation of children. The readiness of Ukrainians to fight and die for their country, and the resilience and determination they've shown in the face of overwhelming asymmetry, is impressive and inspiring. The international community reacted with shock and dismay at Russia's flagrant aggression, and many European nations particularly have felt directly threatened. Who's next on the Russian invasion list? One profound irony of the invasion is that a Russian pretext for the war, at least one of them, was to contain NATO's expansion, and yet the invasion has facilitated precisely that, as Finland has now become a member and Sweden's accession is imminent after Turkey's withdrawal of its objections. But at the International Criminal Court, the invasion of Ukraine has been a game changer. Western media reporting of this war has focused more on war crimes and demands for accountability than I ever remember in any previous armed conflict. States have been rushing to support and to be seen to support not only the Ukraine war effort, but also investigative efforts for greater levels of accountability. This rush to support criminal justice has manifested at the ICC in several different ways. In the granting of substantial additional funds, in addition, that is, to the annual Assembly of States Parties approved budget, the secondment of government experts, investigators, military analysts, data analysts, forensic experts, trial lawyers, the gathering and preservation of evidence, and unprecedented US support for the International Criminal Court, particularly in relation to the investigation of war crimes. For me, it's almost hard to believe how incredible the change has been in the attitude of the current administration. The Biden administration hasn't just offered its support indirectly, but has authorised positive cooperation. And I'm sure that's a direct result of the outstanding efforts of President Biden's appointment of Beth Van Schack as his ambassador at large for war crimes. I heard yesterday that she's coming to the ANU in October. Do yourself a favour and come along and listen to her, because she's an incredible person. The Ukraine team at the Office of the Prosecutor is way better resourced, both in terms of personnel and financial, than any other trial team. I had the privilege of sharing office space on the same floor as the Ukraine team for the 8 weeks that I was at the International Criminal Court in May and June this year, and I interacted with the team as a consequence on a daily basis. They're working hard despite the mountainous challenges they face, and they are collaborating closely with the Ukraine National Investigative Authorities, and the ICC has a large field office and presence of its staff in Kiev. I've got some discomfort about the disparity of resources for Ukraine compared to all the other teams. But I'm not advocating for stripping back the Ukraine team's capacity. In my view, the model of secondment of government experts, sometimes for 12 months, sometimes for 24 months, is a model for all ICC teams. And I'd love to see states parties proactively contributing to increase capacity to the Afghanistan team, to the Palestine team, to all the other trial teams. The prosecutor successfully applied to the pre-trial chamber for the issuance of arrest warrants against Vladimir Putin and Maria Lvova-Bulova in February this year. Although there's no obvious short-term medium prospect for the arrest of either accused and transfer to The Hague, I think there are several outcomes that are worth identifying. In real time, as the war continues on a daily basis in Ukraine, the International Criminal Court has sent a message not only to Vladimir Putin himself, but to his senior political and military leadership that the court is serious about accountability for Rome Statute crimes in Ukraine. Vladimir Putin has reportedly not left Russia, save for visits to the Crimea and the east of Ukraine, since the issuance of the arrest warrant in February. This week he delivered his address to the BRICS summit in Pretoria by Zoom, and now has to think carefully about his international travel plans. Karim Khan has also announced that he plans to apply to the pre-trial chamber for approval to conduct a confirmation of charges proceeding in absentia against both Vladimir Putin and Maria Lvova-Bulova. Let me briefly explain that. The standard that the pre-trial chamber must be satisfied of to issue an arrest warrant is that there are reasonable grounds for believing that these individual accused are criminally responsible for these Rome Statute offences. For a confirmation of charges, which is more like a committal proceeding in those jurisdictions that have a preliminary stage in a criminal trial proceeding, the standard is raised from reasonable basis or reasonable grounds for believing to substantial grounds for believing that these individuals are criminally responsible for these particular Rome Statute offences. The Rome Statute allows for the prosecution to request in exceptional circumstances the right to conduct the confirmation of charges proceeding in absentia of the accused. There can be no trial in absentia, but that preliminary stage can happen. And Karim Khan said he wants to proceed to that stage. So there's some really interesting consequences that flow from the issuance of the arrest warrant, even if Vladimir Putin won't be taken into custody in the next few days or weeks. I think one aspect of this for me that's most interesting is the spectre of the ICC. The possibility that the court can exercise its jurisdiction if it is able to gain physical custody of the accused. The circumstances in which the court has jurisdiction that acts as an incentive for states to behave perhaps differently than they might otherwise have done. And here I'd like to move, before I conclude, to the initiatives in New Zealand, Australia and the UK in relation to inquiries into alleged war crimes by our respective special forces in Afghanistan. I want to talk a little bit more about the spectre of the ICC, where it has jurisdiction. Imagine if New Zealand, Australia and the UK were all speaking publicly about the importance of justice for Ukraine, while simultaneously failing to take seriously allegations of war crimes by our own nationals. Slightly hypocritical position for us to be in. Well, I'm really grateful that it's not the case. In relation to Operation Burnham and the inquiry conducted in New Zealand, the Brereton Inquiry, and now the work of the Office of the Special Investigator here in Australia, and the newly established independent inquiry relating to Afghanistan established in the UK, all of those processes confirm the positive influence of the spectre of the International Criminal Court as an incentive on states to take seriously allegations of war crimes by their own armed forces. All three situations, respectively, involving the National Special Forces in Afghanistan. Sir Terence Arnold and Sir Geoffrey Palmer in New Zealand, General Brereton and Mark Weinberg here in Australia, and Lord Justice Sir Charles Haddon-Cave in the UK have each noted that the International Criminal Court has jurisdiction over conduct on the physical territory of Afghanistan, and the importance of our respective states to take seriously the investigation of alleged war crimes by our own armed forces to ensure each of us benefits respectively from the complementarity formula in the Rome Statute. The complementarity formula which gives primary jurisdiction to the state of nationality. That as a consequence of all of that, we need to investigate our own soldiers and do it properly if we want to exercise that jurisdiction and not let the ICC step in. This incentive, from my perspective, which comes as a consequence of the mere existence of the International Criminal Court with its relevant jurisdiction, in this case over Afghanistan, is a significant benefit from the establishment of the court in the first place. There's no way that the International Criminal Court can deal with all the war crimes, crimes against humanity and genocide being perpetrated in the world. The ICC needs states to take seriously their national responsibility to investigate and, if warranted, to prosecute international crimes perpetrated by their own nationals. Karim Khan, the prosecutor of the International Criminal Court, on multiple occasions has described the work of the Office of the Special Investigator, following on from the Brereton Report, as the gold standard in national investigation of war crimes from his perspective. It's apparent to me that in the UK, the lead of Australia in this respect has had a significant influence on the decision to appoint Sir Charles Haddon-Cave to head up the independent inquiry into Afghanistan in the UK. And he and I have had some conversations ourselves about one benefit, if you are proud of seeing yourself, of self-perception as the great exporter of the common law. Sometimes the former colonies to whom you exported the law might show you up. And in those circumstances, you better rise to the occasion if you want to persist with the mantle of the great exporter. So the question I posed in the title, are we making progress? Let me try and address it briefly by way of conclusion. This International Criminal Court does not represent a comprehensive, impartial, systematic global criminal justice system. It has major limitations to its jurisdiction The fact that it has no jurisdiction, for example, over the Syrian, the Yemen or the Myanmar situations are good examples of limitations to it. And the court struggles for efficiencies and consistency even in respect of the situations over which it does exercise jurisdiction. I can't help thinking of an excellent analysis by my colleague Darryl Robinson in Canada, who talked about or framed what he described as the inescapable dyads that constantly confront the International Criminal Court, the inevitable tensions that the ICC has to live with. Every decision of the prosecutor is contested. And he listed 4 of those. Let me just briefly identify them. The International Criminal Court is meant to be ideal, but it is also supposed to be real. It operates vertically in the sense of administering criminal justice, but it operates horizontally because of its relationship with the Assembly of States Parties. It's supposed to be independent, but it's simultaneously totally dependent on states and on organisations for cooperation and for support and for finance. It should be effective, but it also has to grow its legitimacy. Benjamin Ferencz, the champion of the Global Criminal Justice Project, who we just lost 4 months ago at the incredible age of 103, used to say that it's important to take a long-term view of progress. Don't get caught up in the disappointments of the day-to-day setbacks. Focus on the last 50 to 100 years. As soon as we apply that sort of approach and reflect on the last 100 years since 1923, are we making progress? The only answer to that question in that time frame has to be a resounding yes. We're better off with the International Criminal Court than without it, even though there's still so much to do. Still so much to do to improve and to strengthen the ICC. Still so much to do for states to take their own national responsibilities more seriously. Still so much to do to work towards a truly comprehensive, impartial, systematic global criminal justice system. But there have also been some very significant achievements and notable outcomes over the past 25 years. And I think it's important and right to pause and to laud them. Thank you very much.
Thank you so much, Tim. I'm now going to ask the Honourable Michael Kirby to come up and just say a few words or a few comments in response. His Honour is well known for his work, of course, as a judge of the International Court, judge of the High Court of Australia, but also his work on human rights continued long after he left the bench, perhaps most notably with his role leading the Commission of Inquiry into Human Rights in North Korea. We're very honoured to have you here, Michael, and we're very proud of this lecture series named after you.
As both Imogen and Tim started with dates and anniversaries, I want to mention another anniversary, maybe 2. The first is something we're going to hear, I hope, a lot about between now and the end of the year. That is the 75th anniversary of the adoption by the General Assembly of the United Nations, with Dr. H.V. Evatt in the chair, in Paris on the 10th of December 1948, of the Universal Declaration of Human Rights. I was in 1948-49 attending a public school in New South Wales under the system that operates in that state of selecting so-called bright and talented children out so that they would get special additional education. And my teacher, Mr. Gorringe, in those days you never knew the first name of your teacher, handed out a little pamphlet of the UDHR which Dr. Evatt had distributed from Lake Success in New York to the education departments in Australia. and certainly all children in public schools received the UDHR. And Mr. Gorringe said to us, he had fought in the Second World War in the islands, and he didn't love war. He was not a great one for celebrations of war and glory of war and the fantastic courage of our soldiers. He was against war, and he took pains to tell all of us, his students in his charge, that unless we could take seriously the UDHR, unless we could learn about it as children and give operation to it as we grew older and had responsibilities, then we were doomed because of the development of the nuclear weapons. And he was very prescient and he was very influential, and it wouldn't be a bad thing in Australia if, for the 75th anniversary of the UDHR, if copies of the UDHR were handed out to school children across our country. They don't have a National Bill of Rights, they don't even have a national statute, but we all have the UDHR, and Australia has very important human rights treaties, and the UDHR is the anchor of it, and I think it had a great influence on me. It was printed on airmail paper, which in 1948 was something you never saw. You don't see it anymore now. And I have to explain to young people, that is to say anybody under the age of about 40, what airmail paper was. It's a very beautifully written document. I actually have been around so long that I knew the person who was in charge of Eleanor Roosevelt's commission that investigated the concept of a UDHR. It had originally been intended to be part of the Charter, but as with the American Constitution, they ran out of time, and so it was done in the 3 years between 45 and 48. This development was one in the hands of a Canadian lawyer. Canadians are very good in these things, and I should also say New Zealanders. Feisty little country, New Zealand. It doesn't have a federal system. It can do things that it wants to do very quickly. But the steps that Canada did was to appoint John Humphrey. He was a professor of law at McGill University and a very skillful man. He's lost an arm and he was a no-nonsense person, and he told me, we were both commissioners of the International Commission of Jurists in the 1950s, how he would travel on the bus from his apartment in New York to Lake Success, where the UN was then positioned, and he would get an idea and he would make immediate note of the idea in case he lost it, and that became the UDHR, and that was submitted to that wonderful and impressive and determined woman, Eleanor Roosevelt, and that led to the production of this document in an amazingly short time, given its controversy. Canada issued a stamp, which was actually in one of the rooms which, during the North Korea inquiry, I was assigned, and the illustration in the room was an illustration of an actual Canadian stamp that had been issued with John Humphrey's copperplate handwriting. Like my generation, his, which was a little bit before it, learned cursive writing. And there it was, all persons are born free and equal in dignity and rights. And even to say that to you tonight sends shivers up my spine to think of this concept and what was done And I couldn't agree more with Tim McCormack that you've got to take the long view. And in the long view of universal human rights, we have made some progress. And in the long view of criminal justice for wicked and oppressive people, we have made progress. And we just have to keep at it. When we think of our own legal system, where it took 2 millennia to make a lot of progress, then it's just a blink of an eye, really, to look back at the beginning with John Humphrey, Eleanor Roosevelt, and all the others, Dr. Evatt in Paris, the Universal Declaration, and all of this is the setting. Now, I go on Tuesday to Seoul, and this is for a follow-up meeting to consider the progress, if any, of the report of the Commission of Inquiry on North Korea. This is another anniversary, so forgive me for mentioning it. It is exactly 10 years this year since the COI was established. And the COI report was produced in a way that was very different from most UN human rights reports, because I persuaded my colleagues, and they had no problem with it, that we would conduct the inquiry with public hearings. And the public hearings had plenty of people. North Korea would not allow us to go into North Korea, but they had a lot of people who had fled their country across the ice during the winter into China, and they were available and they were willing and they were anxious to give testimony before the COI. And so we recorded. The UN said, oh, you can't do that, we've never done that before, you mustn't do that, you don't have authority to do it, and so on. But we said, it'll be very risky for you, they'll probably kill you, and we said, we'll take all those risks. And so we had a huge number of North Koreans who came before us and gave testimony. This is something that the International Criminal Court is also experiencing, the desire of people to have vindication, if only with their own memories and their own conscience. And this is a very important feature of the world today, and it was a feature of this COI on North Korea, and it is a feature of the International Criminal Court. How we can get progress. I came tonight hoping that Tim would have a magic wand that I could take to Seoul next Tuesday as to how we could render accountable North Korea for really heinous crimes. How can we make a difference? And of course, North Korea now has reportedly 20 nuclear weapons and missile systems which can deliver them over very long distances, certainly to Australia, probably to mainland United States. So it's a very dangerous country. It can't be just dismissed. The Supreme Leader can't just be dismissed. It's a very dangerous situation, and the ideal solution to the findings which the COI made would be the referral of North Korea to or the leader of North Korea to the International Criminal Court. I agree with Tim McCormack that if things had been attempted earlier, it wouldn't have been possible to establish the International Criminal Tribunal. And likewise, I think with the hearings that we conducted, that would have been more difficult. But you've got to do what Peter Weir, the great Australian film director, showed in Dead Poets Society. You've got to seize the day, you've got to do what you can do. And so we had our hearings, and so many of the people who came forward have been in touch with us since then, saying we have not seen the defendant, but we have seen representatives of the United Nations of the whole world, and you have listened to us, and we have had our say, and it is in the record, and one day there will be vindication. So I think that's the big lesson I take away from this lecture by Tim McCormack. One day there will be vindication, and one day there will be institutions that can respond, and they are in situ. It can't be done next week. It won't be done soon. It may not happen in my lifetime, though my father lived a very long age, and I'm therefore hopeful. But it will happen, and it'll happen because of very brave spirits. And one of those brave spirits was John Humphrey, another was Eleanor Roosevelt, another was H.V. Evatt, another is Tim McCormack. And those who set up and gave life to the International Criminal Court, they will be vindicated and the voices will be heard, and that is the hope that human beings must have for the future of their planet, because without accountability there will be no safety, and without safety there is very great danger. So thank you very much, Tim. It's a wonderful lecture series. I'm really very proud of it. I don't really deserve it, but I grab it anyway, and I love it. And I'm grateful for your contribution, which has been magnificent, both in outside and your work in the United Nations and in telling the story, which is such an important task that you have undertaken. Thank you for your lecture tonight, and I think we should all give Professor Tim McCormack a big round of applause.
Beautiful words.